Thank you for joining us today for our webinar called Furnishing Obligation under the Fair Credit Reporting Act. My name is David Schley from Abrahams & Ginden. I'll be your host for today's meeting. A couple housekeeping items to make you aware of. First, we'll be taking questions at the end. So please add your questions down at the Q&A section at the bottom. You'll see a little button that says Q&A. Place your question there. We'll be going over them at the end. So that's the best way to get ahead. If you have some questions during the seminar, we'll be handling them at the end. Also, we'll be asking you a very short survey, 3 questions. It helps us go back and review, what future type of seminars we want to do. And we'll also be recording this and providing a copy of this recording sometime next week, so you can review this again. With that being said, I'd like now to introduce Ned Abrahamson, partner at Abrahams & Ginden, founding partner at Abrahams & Ginden, to say a couple questions about our firm. Ned?
Thanks, David. Yeah, we're very happy to be sponsoring this seminar today. Abrahams & Ginden is a law firm, obviously, exclusively handling legal collections, both consumer and commercial, for our clients. We work in the states of New York, Pennsylvania, New Jersey, and Maryland at this time. I'm so happy and pleased to work with the lawyers that I work with here at Abrahams & Ginden, with decades of experience in the legal collections area that all of us have. My partner, Josh Ginden, with David Schley and Joshua Borer, who are here today for the seminar. And I'm very pleased to have Lauren Burnette as our speaker today. I'm sure that the information she has to present to you will be informative and very timely. With that, David, I'll turn it back to you to formally introduce Lauren.
Thanks, Ned. Yes, today's seminar, Furnishing Obligation under the Fair Credit Reporting Act, is going to be done by Lauren Burnette. Lauren Burnette is a partner at Messler Strickler. She has been there for several years. She has extensive experience under the FDCPA doing defense work. I've worked with Lauren personally for over 7 or 8 years on a number of cases, and including do some presentation and legislative affairs in Maryland and in PA. So with that being said, I'm very excited to have Lauren here. And Lauren, we'll go ahead and turn it over to you at this point.
Thank you so much for letting me do this. I'm really excited to be here. Like Dave said, my name is Lauren Burnette. I am a partner with Messler Strickler. I manage our Jacksonville and West Palm Beach, Florida offices. I practice law sort of in a patchwork of areas. I grew up as a lawyer in Pennsylvania, and I still practice there. I also practice in Maryland and Washington, D.C., and take cases all over the country when my clients ask me to. So I've been everywhere. And in addition to the FDCPA, I do a lot of FCRA or FCRA litigation, along with other state and federal consumer protection laws and some regulatory work and some legislative work, which Dave has mentioned. I have a real soft spot for the Fair Credit Reporting Act because it looks like such a simple statute on its face, but in reality, there's a real depth there. And, I could spend an entire day talking about one subset of the statute, which none of you guys want me to do right now. So the purpose of today's presentation is to try to give sort of a high-level overview of FCRA and furnisher obligations under the statute. We're going to touch on some of the common areas where I see claims arise in my defense work, and some of the ways that you can keep those claims from happening. For those of you who are not creditors and are not furnishers, but who are attorneys or servicers for creditors who are furnishers, I'm going to touch on some things that you can do to make sure that the trade lines that your clients are furnishing are accurate and are updated timely. And as always happens with these presentations, I'm probably going to have to tear through the last 3 of my slides and just rattle things off really quickly. So if you have questions, please feel free to ask them. My job is not to tell you that I know everything, because I don't. And if I don't know the answer to a question, I'm going to tell you that I'm going to look at it for you and I'm going to get back to you, and I'm going to do exactly that. So feel free to fire away. Starting with the legalese, of course. if I can get my program to run right. I am a lawyer, but I am not your lawyer unless you ask me to become your lawyer, and then I'd be happy to be your lawyer. But this presentation is not intended to be legal advice, and you should always consult with your counsel ahead of making any kinds of, big decisions. Always run it by us first, so we can tell you that the answer is it depends, because that's our stock phrase. So starting at the beginning, what is the Fair Credit Reporting Act and when did it show up? This is another one of the consumer protection statutes that I love to point out is older than I am, makes me feel young. And I think it's really important to look at the stated purpose of this statute because it highlights how FCRA is different from the FDCPA, which we're all used to. And FCRA specifically states that its purpose is to require that consumer reporting agencies adopt reasonable procedures, and this is the important part, for meeting the needs of commerce for consumer credit, personnel, insurance, and other information in a manner that's fair and equitable and accurate to the consumer. And so the reason I point this out is because we hear a lot in the context of the FDCPA and the TCPA and some other consumer protection statutes. Well, debt collector, you did this, but you didn't really have to do it, did you? You could do your job without making a phone call or leaving a voicemail or sending this letter that had some false, deceptive, or misleading statement in it. FCRA is a little bit different because the FDCPA gives a nod to debt collection and states in its purpose that it doesn't want to penalize debt collectors that are complying with the law. But FCRA comes right out and recognizes that the compilation and furnishing of consumer credit information plays a role in commerce. Commerce needs this information so that we can look at lending decisions, so that we can make employment decisions, so that we can evaluate folks for credit. And this, I think, is a nod to the importance of full file credit reporting, which we'll touch on a little bit later. But the reason that I point this out at the very beginning is to suggest that that furnishing consumer credit information and then the CRA's preparation of a credit report and the dissemination of that information plays a significant role in the commerce cycle, and so much so that when Congress enacted this statute, it wanted to point that out, and that plays a really important role in defense of these FCRA claims. I'd also be remiss if I didn't point out that FCRA is only about credit reporting. It's not. It plays a huge role in the employment process. And, that's a separate webinar for a separate day, but I would encourage each of you to make sure that you are familiar with the adverse action process because, a lot of employers unfortunately don't realize that FCRA applies to them, and we'll talk about definitions in just a minute. It's a much broader statute than the FDCPA and doesn't just apply to debt collectors. So let's look at the basic definitions. A person is basically anybody. We are used to the FDCPA limiting its scope just to debt collectors, and some of us have made careers arguing over who is and isn't a debt collector in any given scenario. FCRA, by contrast, basically applies to everything. If you are a living, breathing human being or you are any kind of a business entity, it's going to apply to you. And this is important because for those of you who are not debt collectors and for those of you who are creditors or banks or any other kind of business entity, I don't want you thinking that this is a statute that doesn't apply to you. And that's true, even if you are not furnishing trade lines. It still very much plays a role in your hiring process. A consumer is an individual. And this is important again, because in the context of the FDCPA, a consumer is someone who owes or is alleged to owe a debt. The definitions in this statute are not tied to the nature of the financial transaction at the bottom of the issue. And in fact, they don't even have to have anything to do with the financial transaction. So we're looking at broader definitions here than we are under some of the other consumer protection statutes. What is a consumer report? There's a lot of gray in this area. And I know that each of you is probably familiar with things like debtor message boards. I am on Twitter because my mother is on Twitter, and I like to make sure that my mother isn't doing anything too crazy. But I see a lot of stuff on Twitter about consumer credit reports and what they mean and what they are. And several weeks ago, right after I did a webinar on credit reporting, Credit Karma started to trend because somebody was like, I went to buy a car and my Credit Karma said that my score is 750, but then the lender was like, here's your Experian report and your credit score is like 400. And I'm making up those numbers, but Credit Karma is not a credit report. So there's a lot of gray area around what a consumer credit report is. And what you can use it for. And FCRA touches on the areas that you can use consumer credit information for, obviously for lending purposes. You can use it for employment purposes. And then the statute itemizes a whole list of permissible purposes for which you can access and use consumer credit information. And there are consent provisions all wrapped up in that. Again, there's a depth of discussion in there that I'd be happy to have with any of you. We're sticking high level right now, otherwise we'll never get done. So the statute does not define a user of consumer credit information. And as we go through this, you're going to see that there are still some definitional holes in this statute that the FTC, for the most part, has tried to fill in with its regulatory rulemaking authority. So the statute doesn't define a user. And in this instance, case law is where we're going to get those gaps filled in. And so all over the country, the main thrust of the case law to address who is a user of a consumer credit report is pretty much, everyone from the person who is making the request all the way down the chain. So that includes any intermediaries. It's not, it's not limited to just who acquired it. If you acquire something for a third party, then you are a user of consumer credit information. And the takeaway message on this piece is really that every link in your chain must have a permissible purpose to access and use someone's consumer credit report. The good news is that debt collection is a permissible purpose all day long, because litigation is an acceptable form of debt collection. You have a permissible purpose in the debt collection litigation context as well. So this means that you can access and use a consumer credit report, for example, to try to locate a better address if you're having difficulty serving process. What you cannot use a consumer credit report for is stuff like opposition research. If you have a lawsuit against a consumer that is not a piece of debt collection litigation, there are opinions out there holding that litigation in the broad sense is not a permissible purpose for accessing and using someone's consumer credit report. There's variation on that topic from state to state and jurisdiction to jurisdiction, but for purposes of today, debt collection is a permissible purpose. And so it's not going to stop you from being sued by someone who doesn't understand that. But it gives you a very clean defense. The other takeaway is that permissible purposes are generally not retroactively viewed. So let's say that you have an account that you're going to try to collect through litigation. And in order to accomplish service of process, you access and use a consumer credit report to locate a good address. And the case proceeds to trial and you lose. And you can't recover the debt through litigation because the court has found that you haven't met your burden of proving that you're entitled to it. The fact that you lost that piece of litigation does not retroactively mean that you didn't have a permissible purpose to access and use consumer credit information in the first place. Unfortunately, that's a very common claim, but the case law is very clear that that does not give rise to a FCRA claim. One important piece, particularly for those of you who either lend for or service entities who lend for both consumer and personal use, you cannot obtain a consumer report on someone who has applied for a business transaction. We're going to talk about personal guarantee a little bit later, but that's written into the statute itself, and you need to be careful when you're accessing consumer credit report for purposes of making a lending decision that you've got that permissible purpose piece nailed down. Getting into the meat of the topic of this webinar, which is furnisher obligations under FCRA, the fun part is that the statute does not define a furnisher. It doesn't speak about a furnisher at all. And so the FTC rolled out what we call the data furnisher rule. And for those of you who want to pull it and read it, and I'd encourage you to do it, the appendices are really useful. Your site is 16 CFR section 660. And what the data furnisher rule does is really two primary things. Number one, it addresses direct disputes in a way that may not be fully clear in the text of the statute itself. And it provides clarity in the commentary beneath the actual regs themselves about policies and procedures and reasonableness. So what does the data furnisher rule require? First, it defines a furnisher as any entity that furnishes information relating to consumers to one or more consumer reporting agencies for inclusion in a consumer report. So if you are a creditor and you furnish to Experian, Equifax, and TransUnion, you are a data furnisher. If you are a servicer of someone who holds accounts and you furnish for them, then you are a data furnisher. If you are an attorney or a servicer who does not furnish, you are not a data furnisher. However, you still have a role to play in this puzzle, and we'll get to that in a minute. So the data furnisher rule outlines the steps that furnishers are required to take when they receive disputes from consumers. And so you can generalize your obligations in two sentences. Number one, you have to have written policies and procedures regarding the accuracy and the integrity of the information that you're furnishing to people. You can't furnish in a vacuum. As you know, our compliance management systems are our lifeblood, and you have to constantly test and break and readjust. And your policies have to be reasonable, which is a very squishy term that, unfortunately gives a lot of courts the opportunity to punt, because reasonableness is very often a jury question. More often than not, it's a jury question. But there are some ways that you can tighten your policies and procedures in such a way as to give yourself a real fighting chance at summary judgment. And the second step is that when you get a dispute, you have to conduct a reasonable investigation of the dispute. And we talk here about direct disputes, but that goes for indirect disputes as well. And the question, in FCRA litigation so often turns on what's reasonable. And the data furnisher rule, the commentary beneath gives a little bit of guidance about that. But, generally speaking, that too is a very squishy term that isn't really well defined. And I know that in this industry, we look for hard and fast rules. We look for steps that we can always follow. We look to see where we can mechanize, because when you eliminate human involvement, you eliminate human error. FCRA is one of those areas where not only can you not do that, but you have to have that human involvement, because although there's variation from court to court as far as what constitutes a reasonable investigation, I'd say one truth that spans every court is that you got to have a person involved in that investigation, and you can't delegate it to a machine. So moving on from there, I've mentioned disputes a couple of times. There are two types of disputes, direct and indirect. Direct disputes are disputes that you receive directly from the consumer or someone acting on his or her behalf. Could be a dispute from a debt settlement agency, from counsel, from a consumer's spouse, from someone who holds power of attorney. When we talk about direct disputes, we're talking about disputes that come from the consumer and not from the credit bureaus. Indirect disputes are the disputes that are made by a consumer to at least one credit reporting agency. And what the statute anticipates is that the credit reporting agency then transmits that dispute to the furnisher, who then has to walk the walk of the data furnisher rule. So beginning with direct disputes, again, as we've sort of touched on already, the steps that you have to take are pretty straightforward. First and foremost, you must update your trade line to reflect the consumer's dispute. This is real low-hanging fruit for the FDCPA. When you're aware that a consumer disputes a debt and you don't timely update your trade line to reflect that, you have a 1692E8 violation for which there is no real defense. And if you can tighten up that process and carve your E8 claims out of your litigation inventory, you're going to save yourselves a ton of cash, because there are attorneys all over the country who do this kind of work, and they're very adept. They know what to do. Pull a credit report, check to see if the trade line is furnishing is disputed. And if it's not, there you go. You've got your E8 claim. So I always encourage my clients, the very first thing you do when you get a dispute in is update your trade line, and then don't touch that trade line again until the consumer himself says to you, I no longer dispute this account. And I would encourage you to get a recording of that statement. So you've marked the account as disputed. Now you have to conduct a reasonable investigation with respect to the disputed information. You have to review everything the consumer gives you. We all know that there, again, is a lot of information on the internet. You will begin to see, if you don't see already, use of the same forms and templates, and providing the same information with the CC to the Better Business Bureau and the FTC. Doesn't matter. It doesn't matter where they got their dispute form. You've got to review everything. And then when you complete the investigation, you have to respond to the consumer within 30 days. What we see most often in these is a dispute will come in through counsel, and the response to the dispute will go directly to the consumer. Don't do that. Send it directly to counsel. Don't communicate with a represented consumer. If your investigation yields that you've been furnishing inaccurate information, you have to correct it. Now, the upside to direct disputes, and this says reinvestigation of direct disputes, it should say investigation. The upside is sort of twofold. Number one, you don't have to conduct investigations of certain types of disputes. And rather than rattle them off, I'd be happy to give everybody a statutory citation for this. But if the consumer sends you a dispute that says, my name isn't Lauren Marshall anymore, it's Lauren Burnette, the furnisher does not have to conduct an investigation of that kind of a dispute. The second silver lining is a failure to walk these steps in response to a direct dispute does not give rise to liability against you under FCRA, in the sense that the consumer does not have a private right of action against you. The failure to comply with the data furnisher rule in response to a direct dispute is only actionable by state and federal government entities. So I don't encourage anybody to open themselves up to regulatory liability. That's a mess that you don't want. But liability under FCRA is limited to indirect disputes, which we're going to get to in a second. The second element of the data furnisher rule is that you don't have to reinvestigate a dispute if it's frivolous or irrelevant. And we're fortunate in that, the statute and the FTC give guidance on what's frivolous or irrelevant. We're still talking about direct disputes here. A dispute is frivolous or irrelevant if you don't have enough information to investigate the dispute. When you look at the data furnisher rule, it enumerates the types of information that a consumer has to give you in order for you to investigate. If someone sends you a one-liner that says, I dispute this debt, then you're not going to have enough information to really look deeply into the source of that dispute. And the second basis for deeming a dispute frivolous or irrelevant is if it's repetitive, right? And we see this a lot, repeating disputers that will send the same dispute over and over and over again, with the end game being that you get frustrated, you give up, and you delete their trade line. You don't have to respond to those if they've already submitted substantially the same dispute and you've already fulfilled your obligations with respect to the first one. So indirect disputes is where we see liability in the private civil context under FCRA. And it's a multi-step process. The consumer submits a dispute to the credit reporting agencies through EOSCR. The credit reporting agencies communicate that dispute to the furnisher. They're supposed to do this within 5 days. And the CRA gives you everything that the consumer sent that accompanied that dispute. Sometimes that's nothing. Sometimes it's reams of paper worth of, letters and statements and all kinds of other stuff. You are supposed to receive all of it from the CRA, and only after you receive all of it from the CRA do your obligations under 1681 S2B kick in. And at that point, then you have to conduct your reasonable investigation. You have to review all of the information that the CRA provided you, and you have to report the outcome of your investigation to the CRA. Indirect disputes do not obligate you to communicate directly back to the consumer. And just as a practice tip, I would encourage you not to, only because in FDCPA world, every communication opens up a new channel for litigation. And so if you limit your communications to just the ones that you are obligated to do under the law in this context, you're going to be saving yourself some heartache. So if investigation similar to a direct dispute yields that you're doing something inaccurate, then you have to either modify or delete it or block it. What we see here, this is the meat of most of our FCRA litigation, because a lot of consumers interpret the statute to mean that the furnisher has to prove a negative, right? If information is determined to be unverifiable, and that's the statutory language, well, a lot of consumers will say, you can't prove that I'm not the victim of fraud, right? And of course, none of us are standing right there with the consumer when they make their transaction. And that's what makes defending FCRA claims so complicated, is because it's not a simple motion to dismiss at the outset of litigation since everything turns on the reasonableness of your investigation, particularly when you've got a dispute that involves proving a negative, it can get very complicated. So let's talk about some of the common claims that we see. When is an account in collections? You can report it as in collections starting 180 days from the date of delinquency, and you can furnish for 7 years. Furnishers are required under FCRA to furnish the date of delinquency, and please understand that the date of delinquency is what it is. It does not restart. That's called re-aging, and that's a big no-no under the statute. Something I see a lot are complaints that go something like this. Well, the original creditor is furnishing this trade line, so you can't furnish it too. This, is primarily with assigned consumer debt. And that's not so, because the creditor is writing it off. And it can report that write-off for a period of 7 years, beginning from 180 days of the date of the first delinquency. But accounts in collection can also be reported for 7 years. And so it's very common for the original creditor and the assignee creditor to furnish the same debt. So if someone, sends a dispute, direct or indirect, and says, this can't possibly be right because there are two parties furnishing the same debt, that doesn't necessarily mean that anyone has done anything wrong. I said that we would talk about personal guarantees, and we'll do it really fast. Furnishers can report business accounts on a personal guarantor's credit file, because when someone voluntarily assumes personal liability for a commercial debt, and then the business defaults on that debt, it becomes a personal liability, and data furnishers can furnish information for use in assessing creditworthiness and what have you. You're going to want to be really careful with this if this is something that you choose to do. You're going to want to make sure that you have the terms and conditions of whatever the obligation is, and make sure that they do provide for a personal guarantee. Most do. Most paper is really good at making sure that this loop is tied up, but we see a lot of FCRA litigation over that as well. Going back to a lot of the misinformation that's out there in the world about credit reports, one of the primary sources of FCRA litigation is the simple fact that if you get your credit reports from Experian, Equifax, and TransUnion, and you lay them all out side by side and you look at them, they're not the same. Your credit scores may not be the same from one to the other. All we do as furnishers is push information to the credit reporting agencies. What they then choose to do with it is entirely up to them. So there are circumstances where a furnisher may be pushing that information to a CRA, and the CRA is opting not to furnish it. They've chosen to suppress your trade line for reasons that you may have no idea about. Some CRAs choose not to furnish medical or to report medical debt, or won't report it for a certain period of time. And that's their prerogative. Each credit report is different, but there's, for as much misinformation that's out there about furnishing, I think that consumers would benefit profoundly from learning the roles that we play in the credit spectrum. And so I find myself explaining to consumers and their counsel a lot, listen, I hear you. I'm looking at the credit report and I see what it says, but all we can control is what we tell the credit reporting agency and not what they choose to do with it. And so, you're barking up the wrong tree when you come to a data furnisher about something that the CRA has chosen to do. I think it's also important, just going back 1 second, to emphasize that the absence of a trade line from one credit report does not mean that the presence of that trade line on another credit report is problematic. It doesn't mean that your trade line is defective. Liability under FCRA is twofold. There are willful violations and there are negligent violations. Negligence is fairly self-explanatory. The statute does not define willful violations. The United States Supreme Court has suggested that it includes knowing as well as reckless violations, and the damage model is here. FCRA claims can get very, very troublesome because they do provide for punitive damages, which is not something available under the FDCPA. And when you have a combination of a reasonableness standard that invites jury scrutiny and the possibility of punitive damages, FCRA claims can be scary when you're on the receiving end of them. I'm here to tell you that they're defensible and that there are steps that you can take to protect yourself. Touching very quickly on this, because this is like a week's worth of webinars in and of itself, we're all asking, what role does COVID play in furnishing? Where you make a payment accommodation due to COVID, such as loan modification or payment deferral or forbearance, you have to report those accounts as current, okay? That guidance hasn't changed with the change in administration. You have to keep your trade lines consistent. I've had a lot of people ask about the AW disaster code, and consumers are asking that that be added to their trade lines in some circumstances, and it's okay to do that. Best practices for avoiding liability. Really focus on your compliance management system and your policies and procedures. Make sure that they're reasonable. And that includes looking back to see, what have you missed in the past? How can we tighten this process? It means looking for red flags on a portfolio level. It means paying attention to repeating disputes and checking to see if maybe there's something in your process that you're missing. For those of you who do not furnish, but who service entities that do, timely client communication is key. Because that's going to help you avoid a request for indemnification if your creditor client does get tagged with a lawsuit because you neglected to update or let them know about a dispute in a timely fashion. You're going to want to tailor your investigations to the substance of each dispute, and that's really key. And then train, and document. You're going to want to watch for red flags. You're going to want to make sure that your employees know what to look for. I told you I was going to tear through the last of these slides, and I wasn't lying. So if anybody has any questions, any comments, if you want to reach out to me, please feel free. Here's my contact information. Thank you so much for letting me talk at you. This was fun. And we can do 10 more of these, and we'll touch on some of this in a little more depth.
Well, Lauren, this is Dave. Thank you for doing this for us. We really appreciate this from Abraham again. I do have one question. Can we do one more minute?
Go for it.
Okay. So this comes question that says, if a business entity owner is providing a personal guarantee as part of the business loan application, is pulling the personal credit report considered a permissible use for purpose of considering the business loan?
That is a really good question. And I don't know the answer to that off the top of my head, because on the one hand, you're looking at a business transaction, okay? But the personal guarantee would be sort of consideration for making that lending decision. And then, of course, at the end of the process, if the business defaults, you've got an individual on the hook. My inclination is to say that I can find guidance on that. I don't know the answer off the top of my head, but now I'm going to make myself a note, and I'm going to send the answer to you, David, and you can feel free to disseminate that. Or whoever asked that question, please feel free to reach out to me, give me your contact info, and I'll answer that for you, because that's an excellent question.
Well, thank you, Lauren. Thank you, everybody, for attending our webinar. We'll be doing these future webinars. Please take our survey when you have a chance, and everybody have a great afternoon. And thanks again from Abraham Ginden. Thank you.
Thank you.